Good morning. On behalf of the Institute for Community Justice, I am Asada Thomas, the director. I welcome you to the third day of the Justice, Reentry, and Healthcare Summit. Our acronym for this week is SIGHT, See, Imagine, Grow, Heal, Together. If this is your first day, we thank you for joining us today. If this is your second or third day, we thank you for coming back. Over the past 2 days, we have heard from some phenomenal presenters, and today is sure to be more of the same. In our morning session, we will hear about navigating system in this new world since COVID with our friends from the Public Defender's Office. After which, we will have our virtual Art as Resistance gallery, where we will hear and see from artists through the lens of social justice. Today, in the Art as Resistance gallery, we are featuring three dynamic ladies: Alexis Rogers, Connie Greer, and some women from the People's Paper Co-op. Our afternoon session will be facilitated by Dennis Febo, who will be speaking about his Amend the 13th movement, which would be followed by Donnell Denkins, former juvenile lifer, now working as the election protection coordinator at the ACLU. Our host for today is Khia Naylor. She is the community liaison and job developer at the Institute for Community Justice. Sit back, feel free to ask questions and chat, as this morning's sessions particularly is interactive. So we welcome your questions as you engage with our friends from the Public Defenders Association. So thank you for joining us today. We look forward to an excellent day, and we look to see you on our afternoon session and again Thursday and Friday. Thank you all.
So we're going to try this for the third time. Third time's the charm. So in the past 2 days have been absolute fire. You have heard from people in power and people looking to affect change in the way the world runs today. What we are bringing to you is a call to action, and the time to act is now. More importantly, November the 3rd, 2020. We are the change agents, and we cannot affect change unless we get out and vote. If you are 18 years of age or older, you have the right to vote. You have the right to vote without having to pay a poll tax. You have the right to vote without fear of being arrested. You have the right to vote without fearing for your life or the lives of your loved ones. You have the right to exercise your rights as guaranteed in the Constitution of these United States of America. Your vote or lack of vote places people in power who make the rules that govern the way we live. Judges are elected officials. The district attorney is an elected official, and these are the people who can prosecute and sentence men and women like Tyree Wallace and other innocent folks to death by incarceration. Men and women who do not always know their rights according to the law. Today's theme is grow, and we are planting seeds. Dictionary.com defines grow as to become larger or greater over a period of time. Growth is an increase, and the time to grow is now. We have an amazing group of people presenting today who are change agents for growth. First, we will hear from Kavita Goyal, Mary DeFusco, and Kate Parker with the Defenders Association. They will be presenting an interactive workshop on where and how we can learn to navigate the judicial system in today's new normal. We also have Mr. Dennis Febo with Gazabara Insights, who will be presenting on the need to abolish modern day slavery within the prison industrial complex by amending the 13th Amendment. We will also speak with Mr. Donnell Drinks, who as a child was sentenced to life in prison and now serves as the Election Protection Coordinator with the ACLU and is co-founder of a nonprofit called GROWN, which stands for Gaining Respect Over Our Worst Night. He will talk to us about the importance of knowing our rights when it comes to the ballot box. Artist Resistance will introduce us to 3 young women who are being change agents through their art and work. So as we begin our first session, I remind you it is completely interactive. So please ask questions and we will get to as many as we can during this session. So just as a reminder, come visit us at ICJ. We're located at 1207 Chestnut Street on the 2nd floor, but please call first, area code 215-525-0460. And if you or someone you know is in immediate need, call our toll-free number 1-833-763-4447. Thank you, and let's take this time today to grow together. Ladies, we're ready. Good morning.
Good morning.
So we have your presentation ready, and we're ready when you are.
Okay. Kavita, are we putting up that PowerPoint? Someone putting it up for us?
Yes, I think he is going to take care of that for us.
That's
yes,
awesome.
We're putting up the PowerPoint for you. Okay,
the PowerPoint is up.
Okay. Just tell us when to forward the slides.
Okay, will do. Thanks, Khia. Just making sure we are all that we're all able to be heard. So I'll just introduce myself. I'm Kavita. I'm Community Partnership Coordinator at the Association of Khia. And
my name is Mary DeFusco. I'm the Director of Training at the Defender Association of Philadelphia. We can't hear Kate.
I'm sorry, Kate, we can't hear you.
Good morning. How about now?
Yes.
Perfect.
All right. Good morning, everyone. My name is Kate Parker. I'm the Director of Policy and Practice, and we are so thankful to have this time to talk about what's going on with our criminal legal system. And I guess we're probably ready to advance to the next slide.
Okay.
So today what we're doing is something.
Kavita.
I'll just give a brief overview of what we're headed into today. What we call our Know Your Systems trainings, which is really a set of trainings. And today we're going to be focusing on systems specifically. and what are some of the current challenges with the crisis where the courts have been, backed up and closed for quite a while. So Khia mentioned that we want to keep this interactive. So as you have questions, please type them into the chat. We'll take them along the way. Of course, we'll leave a little bit of time at the end, but it is going to be a tight program. We'll leave a little bit of time at the end for questions, but it's a complicated system. So if you have questions, we're going to try to take what we can along the way. So please just throw your questions in. So I will turn it over to Mary, and if we can advance or just keep on the current slide.
Keep it on the current slide. Yeah, if you would. So right now, the criminal justice system is really in crisis, and we're going to give you some statistics on exactly what's going on. But, for a really long time, the courts were shut down, but the police officers were still making arrests. And at the time that the court first shut down, there were still cases from back in the winter, maybe the fall, that had not yet been resolved. And those cases are still open. And the problem with this is that the right to speedy trial has been suspended pretty much indefinitely. And we've had cases who last March were marked must be tried. In other words, if they didn't put the case on, it would be over. And those cases are still going on. They have not been dismissed. Some people are in jail on those cases. Other people's lives are on hold indefinitely. In addition to that, the court is trying. The court is running virtual hearings. The court is doing some live hearings, but of course, because of social distancing and so forth, they're much, much fewer than they would otherwise be. But problem with virtual hearings is that you have a scenario where the witness is not live. Your right of confrontation and cross-examination, which is the right of everyone who's accused, is kind of eroded by a virtual hearing where you really can't see what that other person is seeing or doing, whether they're reading notes, whether they're being coached. It's very difficult to have a real cross-examination. Some people are going to be pleading guilty just because they're so desperate to get home or to get their lives back. And the problem with this is, it's not like, oh, well, we're just for a while, we're going to suspend the right to speedy trial, and then we're just going to bring it right back. The problem with that is when you give up constitutional rights, and if those constitutional rights are if the delay is on the back of the defendant, that's not something that you're going to get back. I mean, we worked a long time, though, as a country, to get people those constitutional rights that are now being eroded because, well, it's an emergency situation. But the problem is that when that emergency situation doesn't go away, those rights won't come back. So those due process rights protect everyone, every single one of us. And if they go away, they're not coming back. We need to fight for people right now. Next slide. Rita, I think it's you. Can we get the next slide up?
Yeah, great. Thank you so much. And so what can we do about it? And one of the things that we want everyone to take away from this program today and from this training today is that there are more of us, right? And so there are things that we can do to organize around these issues to make sure that people's constitutional rights are not being eroded, right? Because otherwise we're just going to be fighting to get back to zero. Once they're taken away, then you're fighting to get back to where you were before. And so one of the things that we do at Defender and that we're encouraging everyone to do throughout the city is to recognize that not every behavior requires a criminal legal system response, that there are some behaviors that require a social service response, and that we need to do a better job as a city, we need to do a better job as a system, as stakeholders, at separating those types of issues and saying this is a behavior that does require a criminal legal system intervention, and effectively deploy our resources around that behavior rather than use those supports and services for people who don't need any kind of justice system involvement in the first place, right? Not every behavior requires the intervention of the criminal legal system. And one of the ways we do that is by helping people understand what the justice system process is, right? For a lot of people, the justice system is sometimes seen as an entry point to much needed supports or services. And that's a false choice. That doesn't have to be how it is. We can have investment in community support and services without the need for ongoing supervision and compliance of entire groups of people in our city. We have to advocate for people along each step of the process. And we have to recognize that the criminal legal system only works if its response is individualized, that we can't embrace a factory system, a factory model of just case processing. And we have to, when people are entangled in the criminal legal system, when the system gets one little piece of somebody and starts reeling them in, we have to make sure that family, friends, community, support system have access to the resources that they need. Because one of the things that the criminal legal system does is it isolates people, so that they feel like they have to fight their case by themselves. They feel like they have to work only with their attorney, that they have to keep all of these things done in secret, right? Like there's proceedings that maybe are not open. There's information that is not transparent. And what we have to do as a community, and Defender is part of the community, but we're not the only group that's doing this, is make sure that families and friends and support people have access to the resources they need during this very isolating process. We have to engage with decision makers and the media about critical issues, because sometimes the narrative becomes that you have to choose between safety and supporting people who need help, right? And that's a false choice. We do not have to choose between being safe in our communities and having a high rate of arrest and the intergenerational harm that comes from ongoing engagement and an inability to disentangle ourselves from the criminal legal system. Right? These are not like mutually exclusive things, but sometimes folks who are controlling the narrative and controlling the message in the media would have us believe we can only have one or the other. And we have to advocate for policies that call for the preservation of due process rights. That's kind of a legal term. I don't want to throw it around without people knowing like what it means. There's two different kinds of due process. There's rights that are like, is this process fair? Did somebody have the right to come to court and be heard? Did they have the right to like litigate their issue, right? Was the procedure itself fair? And then there's a whole nother group of things that it's called substantive due process. And it's like, is that shocking? Does that sentence or does that punishment shock the conscience, right? And they're the two different kinds of things that we're talking about. And I don't want to be an alarmist. I'm not an alarmist. I'm a very reasonable person most of the time. But if we do not recognize that we are in battle right now to protect the rights of people who are being charged with offenses and being brought into the criminal legal system, we will lose, because there is a real fight going on to protect people's rights. And folks would like nothing more than to sacrifice human beings' due process rights and human rights for the sake of an efficient process, a quick and rapid disposition of cases. And so I think we can move on to the next slide now.
So thank you. Kate, first of all, I'm so glad you mentioned that false choice. So I'm just going to take a moment to mention that our office, the Defender Association, is actually holding a public town hall next Thursday, so a week from tomorrow. And, you know, reach out to us. We'll get you the information. But that is specifically about this false choice that's been set up in our community, that somehow safety means giving up, you know, constitutional rights and freedoms and due process and fairness in the courts. That is never actually really worked to keep us safe. And so next week, Thursday, we will be presenting a town hall, which is a conversation with our chief defender, Keir Bradford Gray, who's going to have a discussion about a people's vision for public safety. So please, join us if you want to hear more about how to engage in what Kate has just gone through, the advocacy for individuals as well as for policy, and how to engage with decision makers on making the right decisions that will help keep us safe and keep things fair. So for what we're going to do today, we're going to focus on the actual system and what's happening at each stage. And if you look at this, it looks complicated if you haven't seen it before, of what happens all the way from arrest through a bail hearing, through trial and sentencing, and even appeals. We're going to go into this in just a little bit of detail. So it's just like, what our chief defender often says, it's like we're opening the hood of the car and showing what's underneath it. It doesn't mean you're going to be attorneys by the end of this. It's like, if I open the hood of the car, I'm not going to turn into a mechanic, but it's going to help me understand things just a little bit better of what to do if I see when there's a problem. So we're hoping this is information that will help people help their loved ones or help their clients to get through the system in a fair way, to have better, fair, more just outcomes because they understood the system. Many times the reason that people get bogged down and clogged up in the system is because they don't really know how it's supposed to work. So they're not even sure how to make it work in a just way, or how to participate in a way that makes sense. So hopefully today's just a glimpse into that. This is a training that we take all around the community. We've done it at churches, synagogues, barber shops. We've done it at community centers and rec centers. It's something that we want to make sure people know about as they help their loved ones or people that they know or themselves through the system. So we're going to jump into this. I want to mention one resource, Khia, if we can forward the slide.
Sure.
Thank you. One of the resources that exists in the community is a network of participatory defense hubs. And participatory defense is a movement across the country. There's hubs like this all over the country that help people navigate the system and really, hold your hand, hold somebody's hand to make sure they understand it. They're not legal clinics. There's no lawyers there. Our office sometimes will send a volunteer just to, be a resource, but these are participatory, which means that you go there to participate in your own case and learn how to navigate it for yourself with a little bit of support. So we just want to make sure that, these are available. And again, reach out to us. We'll give you our email at the end. Reach out to us for any connection with these. So I'm going to turn it back to Kate, I think, for the next slide.
Yes, thank you, Kavita. And so as Kavita talked about, this is our system map. If we do move ahead to the next slide, the very first block that's highlighted is the arrest. And this is the initiation for most folks of the entry point into the criminal legal system. It is often terrifying. It happens quickly. People are usually not given any notice that they're going to be arrested. People are typically not, prepared to be arrested. If any one of us right now were to be removed from wherever we're sitting, taken into custody and held there, for the next 4 or 5 or 10 days, there would be a lot of things in our lives that would need to be tended to and managed, right? And for lots of reasons, our system does not recognize that this is what happens to people every day, right? That people have kids to pick up, that they have phone calls to make, that they have pets to take care of, right? That there is 10,000 things that happen every day for folks that they were not planning on not doing when they woke up that morning. And so what we tell folks is if you or a family member are arrested, we did create a very, I think, helpful handout that gives people information about what to do within the first 24 hours following arrest. The first thing I would say is if someone knows there's a warrant for their arrest, which if anybody has charges pending right now, sadly, the likelihood that someone might be issued a bench warrant that they don't deserve right now is very high. Even though there's a lot of confusion about who needs to come to court and who needs to come to court when, the judges are sometimes issuing warrants when people are not there. And so if someone learns that a warrant has been issued for them or for their loved one, please call our office or assign counsel or your private attorney immediately before turning yourself in. So that way there, your lawyer can support you or your loved one before you turn yourself in on that warrant. I'll also say, if there's any evidence that's on your phone, if there are witnesses who you are going to want an investigator to speak to, even if they're character witnesses, if they're friends, family, supporters, nobody knows anybody's phone numbers by heart anymore. Leave your phone at home. Give it to a trusted person who can bring it to your attorney to get that information from your phone. Photographs, video, contact information for people. This is all stuff that might be very useful for your case and things that your lawyer will not have access to if your phone is secured in your property.
Can I add one thing? Sorry to interrupt. Can I add one thing?
Please.
Before you turn your phone over to somebody to keep it for you, put it in airplane mode, please, because you could lose text messages that are evidence, because once you reach a certain number, depending on what your plan is, it gets a lot harder to retrieve those. Okay, so put it in airplane mode. Sorry.
No, that's very helpful. Thank you, Mary. If you are arrested, and I don't know if people can see the slide, we have the phone number for friends and family to call the courtroom to find out when your initial bail hearing is going to be. And you're going to want to make that phone call so that your friends, family, and supporters know what's coming next. You also want to start preparing documents that tell the full and complete story about you or your loved one. Pay stubs if you're working, health records if you or a loved one have a chronic medical condition or even an urgent one that requires immediate care, information about your family, your roles and responsibilities in your community. All of this information helps tell a complete picture about the person, which is how we are able to successfully advocate throughout the process. And that is what we have for what to do if someone is arrested. If we move on to the next slide, we do have what is a current crisis in our system right now, which is the arrests from the recent protests. And I can't see the crowd right now, but I would ask people to think whether they or their loved one, a family member, somebody in your house participated in any of the recent protests for civil rights throughout the city of Philadelphia. If you've seen it on your Instagram or Twitter, if you've seen news footage of those protests, and I want you to think about the diversity of the people who were attending the protest. People from all walks of the city were coming together during those protests. If you remember the footage from the tear gas on Vine Street, and remember all of the different footage from that it was a very visually diverse group of people in terms of race, in terms of age, gender, all walks of life coming together. But when we look at the demographics of who has been arrested related to those protests, we do not see a representative sample of the people that I saw out in marching and walking and participating in those protests. And what we see right now is about 500 people were arrested related to the protests against police and violence that had been perpetuated against people of color throughout the U.S. Our arrests have extreme disproportionality. 72% of the people who are arrested are Black. Almost half of them were under the age of 25, with 3/4 of the arrestees being under the age of 35. Most have never had an arrest prior to this interaction with the criminal legal system, which is a very difficult thing to do. It's actually not terribly difficult to be arrested in the city of Philadelphia, particularly in communities that are over policed. And we know that upwards of 40%, 50% of people who are arrested, those charges are ultimately dismissed anyway. And so over half of the people who have been arrested during these protests have never had a prior contact with the criminal legal system. And these charges are still pending. They've not been addressed. They're part of the backlog of cases. As we enter into the fall of COVID and into the economic crisis, continued challenges with housing, continued challenges with employment, we have approximately 500 people who will have a charge pending over their head until it's resolved in some way, until it's disposed of some way. And there is not a pathway right now to effectively resolve these cases. Now, the creative solutions exist around the country. There are restorative models that we can model our behavior after, but we haven't implemented them here yet. And so we are actually calling on folks, if this is a priority for people, to let your elected officials know that, and to explore whether there are opportunities to dismiss charges for people who have no prior contact, who are participating in a civil rights movement, whether there's opportunities to divert these cases so that we can make sure that people don't unnecessarily be tagged with a criminal conviction that will follow them for the rest of their lives. 15 years from now, there will be no checkbox to indicate, well, that was the protest arrest, right? There won't be a method to explain I was engaging in protests related to a real civil rights moment in my country. There will just be a conviction, or there will just be an arrest that shows as pending. And so this is a real crisis that we're facing right now. And for those folks who love the data, the next slide does have our breakdown in terms of the racial and ethnic disproportionality in the arrests. And I would call on people to think about what they saw on the news, what they saw in the streets, if they were actually out there, to say, does this disproportionality accurately reflect who you saw protesting during that time? And the next slide has the information about the ages of the age distribution of our clients who are charged with protests related incidents.
Yeah.
I can't tell if we moved to the next slide or not.
Yes, we moved to for the
Yes.
Perfect.
yes.
Thank you. And I'll just leave that there for my note takers. I know some folks do take notes. Before moving on to the next slide, and I think that goes to Kavita.
I think, Kate, that's good.
Okay, we have a couple of questions that have come in. So a question from
Great.
Jacqueline Buchanan. She just would like to know, are we talking about looters or protesters?
So there is no actual crime that's called looting, right? And so that's kind of a tough question for us to answer because there is like a historical context with that word in terms of what sometimes it refers to. The charge distribution that we see is overwhelmingly non-person offenses, overwhelmingly non-violent offenses, and the allegations are hard to tell what behavior is specifically being charged. And so if I am present near a particular place and someone else has broken a window into that place, we have a group of people who are still charged for, being inside that property. And so it's very difficult for me to answer that question. I want to honor the question, but for us, what we're calling for is an individualized assessment of the behaviors that are being charged, and to say, is this the type of behavior that requires a criminal justice response? Or is there a pathway forward that recognizes the historical context of that moment and looks at the behavior itself as one moment in that person's life relative to the totality of their entire self and their entire person? And so for me to answer that a little, go ahead, Mary.
Yeah, if I can just jump in here with a real, what I think is a common sense kind of thing. So you're a young person, right? You've never been involved in any kind of a protest. You want to do a peaceful protest. You go out in the street, you're surrounded by a ton of other people. Somebody breaks a window and a lot of the people around you start moving in a direction. You don't necessarily want to go in that direction, but it's really hard to stop the crowd. You could easily get trampled. So I have been in very large crowds. I'm a lot older than a lot of people, I think, who might be at this thing. And so I have the experience of sometimes you're in a crowd and the crowd is doing stuff you don't really, that wasn't your plan. That wasn't what you intended. That wasn't why you were there. But you get stuck and you get tarred with what happened with the crowd. So what Kate is calling for here is, let's make a judgment about this individual. Let's look at their past. Let's see if this is really what they intended. And let's make sure that we're not pulling into the criminal justice system the kind of people that shouldn't be here for actions that shouldn't bring them here. And so I think it's not so clear to be able to say protester versus looter. They make it sound like it's clear difference, but sometimes it's not.
Yeah, and I don't want to. I want to be mindful of our time. I tell this story all the time. I was in DC and I was protesting probably more than a few years now, right? Maybe 20 years ago now, and I stopped in to get a coffee during my march because that's the kind of protester I was. And when I came out of the protest, I got back into the march and started walking again, and the people were protesting the entire existence of Israel, right? And I was said, oh my gosh, these are not my people. Like, this is not what I was here to do. And yet in that moment, I was with a group that I had no intention of being with, that I wasn't part of that protest. I was there for an entirely separate issue. I was there for something having to do with a war initiative, and had to find my way out of that group, right? But if someone had started the camera and just rolled that footage right at that moment, they would have made all sorts of assumptions about why I was there and what I was doing, and my intentions and all of that, none of which would have been true or an accurate reflection of me. And so I hope that answers your question.
Okay, I hope that answers Jacqueline Buchanan's question. And just remember, this is interactive. So if anybody has any questions, we can see you. And actually, she says thank you. So we can see you, and we will put up these questions as we see them come in.
Kate, I think it's still you.
Oh, can we move to the next slide?
I'm not sure if
Can you see the next slide?
Yes, I can see it. And this is for the bail hearing, is that correct?
Yes.
And I'm so sorry. At this bail hearing, what's going to happen is that our decision maker is going to decide whether this person who's in front of them ought to be released or ought to be detained. And when they make this decision, during the ordinary course of things, they have about 2 minutes of information to decide on. And this is the information that our lawyers have. And so we need to make sure that we have as much information about the totality of the person at this preliminary bail decision, because the bail decision is one of the most important decisions that happens in the life of a criminal case. And while if you think about all of the information, if your brother or your sister, your son or your daughter, your aunt, your cousin was arrested right now, what types of information would you want the person deciding whether they should be detained or released to know about? That's the kind of information the attorneys need to be able to present to have the best chance at getting the person released. Now, the court will have a few options. They will be able to detain the person. They will be able to set a financial condition that the person has to pay before they're released. They can release them on conditions of supervision by pretrial, or they can release them on just a promise that they will come back to court. Our concern with the financial conditions of bail are always that they don't really keep us safe, right? I want us to think very generally about what amount of money would actually keep us feeling safe if a person that we wanted to be in jail had to post it, right? And that number is probably none, right? And that's why we encourage a much more transparent process than is happening right now. What happens right now is the judge sets an arbitrary amount of money. If the person has the ability to pay it, they're able to be released. If they don't have the ability to pay it, then they stay incarcerated. And we call for a much more transparent system, one that makes the district attorney's office ask the court to hold the person if they feel like they present legitimate public safety challenges that can't be mitigated by supports in the community. And then we call for the overwhelming majority of people to be released with the least restrictive conditions necessary to support the person upon their release. And that hearing happens within pretty quickly after the arrest. And so it's really important that we get the information to the attorney as quickly as possible. And then I think we can move on to the next slide for that.
Kate, I think that's your slide.
Oh my goodness, I'm so sorry. Thank you, Mary. I wrote down a different note for this one.
I mean, I can talk about it. That's fine.
No, it's no problem at all. I'm happy to do.
All right, go ahead. Go ahead.
So right now, pretrial detention is a current crisis. We want to make sure that we understand that just because people who are charged with crimes, I shouldn't say the overwhelming majority, but half of the people are never convicted of anything. They're never found guilty. These charges are dismissed completely. And so it's very challenging when we're making these decisions about pretrial detention, not to think about what is the likelihood of conviction, and are we punishing people before they have the opportunity to litigate their case or to be heard. Of those who are convicted, 4 out of 10 of them, they don't receive additional periods of incarceration. And so it's a very challenging thing. I want us to think about, does it make sense that we have a system that on Tuesday, this person is the most dangerous person. We say he's the most dangerous person. He can't be released. He can't be in the community. And then as soon as that person pleads guilty, as soon as that person is sentenced, they are released in the community and they're standing behind all of us at the deli counter, at the grocery store. Is that compatible, right? That on Tuesday, somebody can be the most dangerous person, that they can't be released, and then on Friday, they are released. And they're there's nothing that's really changed in terms of the supports that that person is going to be receiving in the community. Right now, this is particularly problematic because of the significant delays and the backlogs in case processing. And so we have people who are pending charges. They're facing a likelihood that the case will be dismissed, a strong likelihood that they will be released at some point, and yet they're sitting in jail unnecessarily, waiting for their day in court with little certainty about when that is going to be. And so, and Mary mentioned it earlier, and we should talk about it. We're going to keep talking about it because the only reasonable check on pretrial detention, if someone is detained without being able to be released, a presumptively innocent person, right? They're not any different than anyone else who hasn't been arrested under the eyes of the law, right? The person is an innocent person. It is a hallmark of our judicial system. And we have that person who's now sitting and their speedy trial rights have been largely suspended. And so we have folks who might not have their day in court until January, February, March of next year. And the only check that our system has on unreasonable delays in pretrial detention is the right to a speedy trial. It's the only thing that keeps the system honest. Otherwise, you're just holding people who haven't been convicted of any crime. And we would be remiss if we didn't talk about pretrial detention within the context of its impact on people of color and people with limited access to financial resources. In a country where we know communities of color don't have the same access to intergenerational wealth, they don't necessarily have the same access to property, they don't necessarily have the same few $1,000s sitting in an IRA account or a retirement account or some savings account somewhere through no fault of their own. When we talk about making people's freedom conditioned on their ability to pay, we inevitably see, almost intentionally see, disparities in communities of color who simply don't have access to the wealth that is required to pay for freedom. And we cannot allow that to continue. We cannot, under the best of circumstances, we can't allow it to continue. But right now, when we have no other check or balance to this detention, we cannot allow communities of color to sit in detention into who knows when, who knows how long, simply because they lack the resources or the financial resources to post bail. It doesn't have to be that way. There are other models to follow, which we are not following here in Philadelphia. And so that is a crisis that needs to be resolved. And for people who are interested in this issue, there is so much research and information available online. Also, I don't know if we've given them out. My email address is kparker@philadefender.org. I'm happy to talk to people about pretrial detention and cash bail forever. You will get tired of hearing it. But it is, in my mind, one of the greatest civil rights injustices that's happening right now. I want to also say that aside from the suppression of a piece of evidence that is an element of the crime, right? I'm charged with drugs and the drugs get suppressed. And so now there's no drugs to use against my case. The decision about who is detained and who is released, that first detention point, has the greatest impact on the outcome of someone's case. What we see, and we see it nationally, but also here in Philly, is that similarly situated people who are detained pretrial have a greater chance of pleading guilty or being convicted. They have a greater chance, if they are convicted, to have a custodial sentence imposed. They have a greater chance of having a longer custodial sentence imposed than similarly situated peers. And now there are some people who are I don't care what happens to defendants, right? We don't love those people, but there are groups of people who think that way. If you care about public safety, you care about this, because people who have been detained for even a short period of time as 3 days are more likely to be rearrested during their pretrial period, and they are more likely to be rearrested within 2 years of the final resolution of their case. And so if you care about public safety, you care about equitable decision making at that bail hearing, it impacts all of us in ripple effects of consequence in ways that we are only beginning to understand. And so I had the mic, and so I urge everyone to get involved in this particular issue. And I'm also happy to kick it back to Mary, who might want to add some things too.
Well, thanks, Kate. We can tell that you know. Don't hold back, Kate. Tell us how you really feel about pretrial
Right,
detention.
exactly. The passion is there.
Listen, she can't be too passionate on this issue. If you could see what goes on in courts and in jails across the country, every one of us would be just as passionate as Kate. So we're going to go to the next slide, because we want to talk about preliminary hearings, which is probably the most important portion of this piece before the trial, right? So
Mary,
whether you're, yeah. I'm
Mary,
sorry.
can I just say one more thing?
Yes.
On the previous slide, moving on, if you can hear me okay?
We can hear you now.
You know, okay, I don't know what happened there, but thank you. If we could just go back to the previous slide for just a second.
We can go back to the previous slide.
I just wanted to, you know, with everything that Kate just said about the number of people who are being charged and just waiting and waiting and waiting for their case to be resolved. And, you know, we already know from years of research that about half of them will never be found guilty, and another, you know, almost another quarter of them will never be sentenced to incarceration. They might just get probation or, you know, something else. And that other jurisdictions are finding ways to use restorative practices that have a way of healing communities and allowing communities to move on and actually be safer. It just puts that whole question that came up, which I think was a really important question about the, you know, the protesting and looting. You know, I'm so glad, Kate, I'm not a lawyer. Mary and Kate are both attorneys. I'm not an attorney. And I just needed to hear when Kate said, you know, looting's not actually a category of crime. It's actually something that was created as a word in the media for many. And I remember hearing the same word before I ever worked with a Philly defender when Hurricane Katrina happened. Where certain images came out in the newspapers showed as looting, and then other communities were shown doing the same thing, getting a bag of, you know, bread and shown as providers of their family. And one thing that our chief defender just spoke about Monday during this summit that I wanted to highlight is that there are behaviors that happen in our communities that are treated radically different depending on where you live, what neighborhood you come from, and what you look like. And that's just the truth. You know, there are people, and we saw that graph that's really intense that Kate showed. About 72% of the people arrested at protests and being charged right now are Black. And we know that this has happened before. This isn't the first time. It's happened during the civil rights movement. It was talked about then. I think the words like looting and thugs came up after that. And we saw it at crises like Katrina, where Black people are presented differently when they have the same behaviors, while we might have people in another part of town or in the suburbs who are given another way to deal with the crisis that they're, or provided social services, or provided a different pathway. And right now what we're seeing in Philadelphia is that these protest cases, there actually isn't a pathway forward. They're just on hold, which means people could lose their livelihood and be more desperate. And that's when we start to see recidivism. And so I think we really have to question for the community of, you know, what do we use the criminal justice system for? Is it to punish people, or is it to have safer communities and to protect people? And I think that's a question that we really have to dive into. I feel like you all are diving into this all week, and we're going to have that public town hall next Thursday, so I'll make that one more plug. But, you know, this is a larger question than what happened this one day. It's about how do we use the criminal justice system to keep ourselves safe to protect ourselves, and also to be fair in the way we mete out justice in our communities. And I think that's what this whole week of forums is all about. So we really have to dive into that. So I hope you'll, come back and talk to us more about this. So that was it, Mary. I'll get
Thank
off
you,
my.
Kavita. I'm so glad you said that. I think that was so valuable for us to hear. All right, so let's get the screen up to the preliminary hearing if we can. And just for a second there, my screen and everybody froze. So if that happens again, somebody, Kate or Kavita, take over, okay? So the next screen up is the one that shows your preliminary hearing. I want to issue a disclaimer here. If you are charged with a misdemeanor in Philadelphia, you will not get a preliminary hearing. You will have a municipal court trial before a judge. So you should know and talk to your lawyer as soon as you get arrested to know if you're going to fit through the felony system, which is what we're showing you, or whether you're going to go to a misdemeanor trial, right? So the next two boxes, preliminary hearing that you see bigger on your screen over there, and formal arraignment only apply to felonies. So keep that in mind. So at the preliminary hearing, what happens is the judge listens to a witness of some kind. They have to call it a live hearing. It looks like a trial, but it is not a trial. Because if that witness says that you committed a crime, a felony, right, then you can bring in 10 witnesses, 20, 100 that say that that witness is either wrong or lying, and it won't make a single bit of difference because under the law, the judge just has to take as given that what the witness said was true and accurate, right? So the question here for the purposes of the preliminary hearing is, do they make out the charged felony? If the felony is made out, then the case is held for court and continues along this line to formal arraignment, as you see in the next box. If they make out a crime, but it's not a felony, it's a misdemeanor, the case is remanded, that's the word they use, sent back down to the court, the municipal court, for a trial before a judge. And not to the court of common pleas. It's only a misdemeanor charge now. And if they don't make out any charge at all, any kind of crime, it's discharged for lack of evidence. Now, if the case goes forward and they don't have their witness and they're not ready, they get 2, 3, sometimes 4 and 5 continuances. And then ultimately the case is discharged for lack of prosecution, what it is called, right? So what can you do? So very quickly, call your lawyer's office as soon as you can, right? If you've gone through that first box that Kate was talking about, bail hearing, and you got a lawyer somewhere in there. They either told you to go hire your own attorney, or they court appointed you an attorney, or you assigned the attorney from the public defender's office. Whatever it is, go and see that lawyer, bring as much information as possible. I'm not going to go through again what Kate mentioned about cell phones and evidence. Very valuable. Make sure that you're doing that as well, right? And get ready for that hearing, because that's another chance, especially if you're incarcerated, right? It's another chance for you to get your bail reduced and released, right? If they're not ready, if they don't make out the crime charge, even if they make out the crime charge, but the bail is still too high, you have a shot, right? So let's go to the next slide, right? Because what does all this mean now that we have Corona, right? Because this was always true of preliminary hearings, but what happens with preliminary hearings in the middle of Corona? Well, the backlog for people in jail can mean endless months of time in pretrial detention without an end in sight, because the speedy trial rule has been suspended. So the usual 1 year from complaint to trial has been suspended, right? For those who are out of custody, you're just waiting and waiting and waiting and waiting, because no one really knows exactly when that hearing is going to go on. Let's say you do have an in-person hearing, because the court is having hearings. They're having different courtrooms spaced apart. They're having 3 hearings at 8 o'clock in the morning, 3 hearings at 10 o'clock in the morning. 3 hearings at 9 o'clock and 3 hearings at 10 o'clock, right? So that's how they're trying to handle the in-person hearings. That's not even the virtual hearings, right? But if you have an in-person hearing, you are limited. You cannot bring in your family, your friends, your supporters. Ideally, one of the things we used to tell people when we did this training is, hey, go out to a hub, find people, let them know about your case, get your friends, get your family, people who know you, bring them to court for you, because they can tell the judge that you're not going to run. You're not going to take off. You're going to be a good risk of appearing at trial. Well, now you don't have that option because they're not going to let you bring all these people into the courtroom, right? If you decide, all right, fine, I'm going to have a virtual hearing. I'm going to have a virtual hearing. You will get one tile on that Zoom call, essentially, for your family members, right? And you can have as many as you want, but they have to be in that one location, right? So you can't just have a number of tiles for different people, right? And the problem with those Zoom calls, as I think I mentioned earlier, and I'm not going to spend a lot more time on this, is you don't know what that witness who's being cross-examined has in front of them and whether or not anybody's whispering in their ear. You just don't know what's going on there. Now, we have had cases, I think I said earlier, that were marked must be tried back in March, and they're still going on. So because of this situation, a lot of people are going to plead guilty who are not guilty, who would otherwise fight their case simply because they have to try to get to work and try to go on. And this kind of squeezing this crisis onto the poor and onto the people who are at the bottom of the system makes things even worse in terms of desperation, in terms of what's going on in every family. All right, next slide. I'd like to show you guys formal arraignment, right? Formal arraignment. So what is that? Well, formal arraignment is confusing right now because I was sitting at preliminary hearings on Friday, right? We were doing preliminary hearings and the judge held a couple cases for court and said to the defendant, if you're not there, we're going to issue a bench warrant. And the crier said, oh, Your Honor, they're not allowed to be in the room. They're not expected. Their presence is waived. And the judge said, is that right? Because I still have the notice here that says if they don't show up, they're getting a bench warrant. So there's a fair amount of confusion even inside the system itself as to what's going on, right? So, but just so you know, for formal arraignment purposes, it was just a placeholder for a date. The district attorney would turn over police reports, right? And they would just give it a date for the pretrial, right? And the pretrial, next slide. At the pretrial is the first time that you're really getting some type of offer for your case, right? And again, this is an opportunity for your lawyer to advocate on your behalf with the prosecutor. This is really the first chance. They don't really have much of a chance to do that pre-preliminary hearing, pre-formal arraignment, right? So all of the evidence that you have, it's very important that you speak to your lawyer about it right now. So once again, next slide. What's happening because of Corona? Well, this is also impacting trials. So on the next slide, we're going to talk a little bit about these delays that are happening, right? I don't know if you guys are able to advance that. There we go. So again, when I was in court on Friday, what I saw was that, you know, everything's been suspended, speedy trial rights are suspended, but yet when the person didn't appear in court because there was a question as to whether or not they had notice of their court date, the district attorney asked the time to be calculations, right? And the problem with that is, yes,
could you
the time.
Yeah.
I'm sorry, did I freeze up?
Yes,
I
you
love
did.
it. Just repeat what you said.
Apologies.
Yeah.
So what happens is that when in that case there was a client who didn't appear and there was a real question as to whether or not he had gotten notice. Can you guys hear that? Is everything all right? Mm-hmm. Good. It was a real question as to whether or not he had gotten notice, and the district attorney asked for the time to be ruled excludable. What does that mean? It means that it's not going to count. All right. If they have a year to try the guy, that time period where they didn't give him notice to come to court and he wasn't there, that's not going to count. And here's what's crazy about it. Well, then if that time doesn't count, then how about the regular time, the time when the Commonwealth isn't ready and doesn't have their witness? Does that time count? Well, that time's suspended. So it's 6 of one, half dozen of the other. Bottom line is this crisis is impacting the speedy trial rights of the weakest in the system. It's causing everything to clog down in the system. And we need to do something about this because, as Kate said, those rights, those due process rights are all of our rights, right? All of our rights. So if we're just squeezing them out, we're just making sure that we take care of this crisis on the backs of the weakest, that impacts us all. All right, I think Kavita, that takes us to trial, and that would be you.
Great, thank you, Mary. And you can hear me okay? Khia,
yes.
We can go to the next
We can hear
slide.
you. So we can go to the next slide? Okay.
Yeah. And I think by now, you all just went through so much detail. Let me stop and say, if you look at where we are on what some people call this assembly line, we can keep on that slide, Kia. I'm just going to kind of point something out. Where we are in this assembly line, even in normal times, non-crisis, non-COVID, 6 months have easily gone by. A year might have gone by. You're just waiting for your trial. You're still in our system supposed to be considered innocent until proven guilty, but you just waiting, whether it's in custody, which is the worst of it, or even on house arrest, which has its own constitutional issues in terms of being innocent until proven guilty, or even if you are on like a pretrial probation or whatever it may be, it may have impacted your job. You might end up losing jobs and benefits because just the arrest, and you haven't even had a chance to try your case. So you're waiting and waiting and waiting. And as Mary just pointed out, that's way, way worse now. As both Kate and Mary have said, each of these stages is delayed, or some are not happening at all. Some we've already been told have been pushed off till 2021. So folks who might have had a trial that should have happened back in last March 2020, and it was marked must be tried, there's a possibility it's not going to happen until 2021. And during that entire time, as you're waiting, your life is on hold. You're waiting to resolve this, and in the meantime, anyway, there are other paths to this. Let's go to the trial stage. The trial stage. The other part I was going to say is, and now let's say it's been 6 months to a year, and that's on a good day without COVID. You've been waiting this long for your trial to resolve, and now you're finally getting a chance to make a so-called deal, right? And Kate talked about this. So now and Mary, you just mentioned this is one of the first times at pre-trial where you might get offered a deal. It goes back to something Kate said. So you might have been kept in custody for 6 months to a year, dangerous, too risky to be let out. You've been held inside, and the next day, the district attorney is offering a deal where you might get out sooner. And suddenly, if you take the deal and say that you really did do this thing, and you've said you're innocent the whole time, and now you say, okay, I need to get back to my home, I need to get back to my family, I need to get back to my job, you might sign off and say, yeah, I really did it. And now you're allowed back out just because you said you did it. That's not justice. There's some great documentaries that are out there right now because people are waking up to system harms people and harms communities as a whole. So if you're interested in this particular topic, there's something that was made pre-COVID called The Vanishing Trial. The Vanishing Trial, where our systems across the country, and especially in Philadelphia, are trying to speed through and have fewer trials and instead come up with these deals. And there's some pressure to take the deal, because if you take the deal, you get fewer sentencing years than if you go to trial and get convicted. They tell you they're going to give you the max.
Okay, I hate to interrupt, Kavita. I'm sorry, I hate to interrupt. Our time is winding down. We've got about 4 minutes left. I'm sorry, this was such informative and so passionate. So just to ask a quick question, where can folks find information on like the participatory defense hubs and further information with the closure of COVID? Is there a website we can go to? Phone numbers we can call?
If we can go ahead and take like the next 4 to 5 minutes and get slides, we'll just commit to doing that. How about that?
Okay, that's fair. So actually we're down to about 3 minutes.
Okay, I was hoping we had a little bit more flexibility than that, Kia, but I'm going to try to move through as fast as I can.
Thank you.
Let's go on to the next slide. Yeah, let's keep going.
Okay, to the next one.
Yep. The next one.
The next
one. Yep. Slide 21.
You got it.
Great.
I don't see it yet. I think we're going backwards.
Keep going. Keep going. Again. One more. Okay. There we go. Is that the one we're looking for? Thank you.
Yep. Yes, it is.
Yep.
Okay, so I've just been told we're going to make up some time for you.
Uh-huh.
Awesome.
How long do we have?
How long do we have? About 5 minutes.
Okay.
All right, thank you. Sorry about that, ladies.
That's okay. One thing we want to leave people with, we didn't get through all the headaches of the trial right now, but you can imagine, based on everything else, how much people are waiting and people are giving up rights. And so one of the things that's already been emphasized is whenever we're in the middle of any crisis, the worst of the crisis, and this happened, I mentioned Hurricane Katrina, any recession, it happens, and the worst of the crisis falls on the backs of the individuals and the communities who are the most vulnerable. And we start making exceptions. We use that as an excuse to make exceptions to human rights and constitutional rights. We don't let that stuff happen around the world without comment, but we're letting it happen in our own backyard, really. We're letting these rights become systematically eroded. And when we don't defend them, it just goes on and on. It just perpetuates itself. So now is the time to really do something about it. So I'm going to ask Mary and Kate at least to say a word each about what people can do about it, and we'll have our contact on the next slide.
Go ahead, Kate.
Sure. So in terms of what we can do about it, we want to ask people to think about what the system's going to look like if we are honoring the rights of the people who are accused. And to that extent, let your elected officials know that this matters to you. I'm not ever going to tell people what to say, but I am going to encourage you to say it loudly, to know who your city council person is, to know who your DA is, to learn about the decisions that the judges are making. In a world right now where everything is up for grabs, where every institution and system is being asked to do more with less, I'm going to ask that you let people know that this is a priority for you and for the people that you care about. And if you have any questions about, what bills mean or what the system is or what changes this actually has, please feel free to reach out to us directly. We're happy to educate, to inform, to answer questions so that people can make their own informed choice. Never going to tell people what to think, but going to give you the background information that you might need to make an informed choice.
And thanks for that, Kate. I'm going to echo that. And one of your elected officials is the district attorney. So keep in mind, and I truly, truly wish that all of you who are seeing this right now could have a window into what happens every day in the courts in Philadelphia. And just as one example to try to give a concrete face to this, we had a client who they sent a notice to him. And it came back, person doesn't live there anymore. And they said, well, he has a responsibility to inform the court. So we're asking for a bench warrant. In other words, lock him up, judge, lock him up and hold him until we're finished his trial. Well, here's the problem. If he was made homeless back in March, who was he going to notify? Our office was closed at that point. It took us a while to reopen. The courts were closed much longer than our office was. Who was he to notify? Right. And yet the district attorney continually pressed for a bench warrant. Who does that benefit? The system just tends to roll along. I think Kavita called it a factory. And I think she's right. And we have to stop the factory. We have to let those in power know that we're not all about a factory system of injustice. We're about a system that sees people as individuals and judges them for who they are as a whole and keeps the community safe. And we can only do that if we get involved and let those in power know how we feel.
Thank you. Thank you, ladies, so much for your fire and your passion and to keep this ember that we've had growing and, for today. So I'm going to personally thank each of you for coming and sharing and enlightening us. And I believe we had some information on the final slide where people can contact you. If we can pull up the final slide.
If you would flash up the final slide, that's my phone number and email, and it's KGOYAL@philadefender.org. And our website is also www.philadefender.org. And you can also reach out to me if you'd like to be part of this town hall. It's a public conversation. You'll be able to contribute to the conversation next Thursday, the 15th at 3 p.m. And if you reach out to me, I'll make sure that you get information on that. This is an ongoing conversation. And if you do want a glimpse inside the courtroom, we can connect you with these community defense groups, the participatory defense groups that are doing exactly that to help people get through the system. So there are a lot of ways to get involved, including just calling your elected officials and letting them know this is not what you want happening in your name.
Exactly. Thank you, ladies. And remember what Ms. Goyal just said, elected officials. This is who you put in power when we go out and vote on November the 3rd. These are the people that you're choosing to basically represent you. So please choose wisely and be mindful of that all the time. So just once again, thank you so much for your passion and your drive and just the power and just help watering our seeds to continue with growth and knowledge when it comes to our rights and navigating this criminal justice system. So next coming up, we have Art as Resistance, where we will be meeting Miss Alexis Rogers, Miss Connie Greer, and Courtney Bowles of the People's Paper Co-op. And this is a quick reminder that for each webinar coming up, you have to register individually. So please, we've got Mr. Dennis Febo coming up later this afternoon. We have some great webinars tomorrow. And of course, Friday with our keynote speaker, Mr. Tyree Wallace. You don't want to not register and miss that. So I'm encouraging everyone to please remember to register for each webinar separately. Once again, thank you for the Defenders Association, Ms. Goyal, Ms. DeFusco, and Ms. Parker. And next we will have Art as Resistance.